Welcome to our speaker event on a very timely topic, protecting human rights in supply chains. We're looking forward to a very stimulating panel discussion with a distinguished group of experts. I'm Bruce Aronson, Senior Advisor to the Japan Center of the U.S. Asia Law Institute and also Adjunct Professor at NYU School of Law, and I'll be acting as the moderator today. We'll dispense with the full speaker introductions to maximize our time for discussion. For speaker bios, please refer to our website. Very briefly, our speakers today are Noor Hamadeh, who's Advocacy Counsel at the International Corporate Accountability Roundtable, Hideaki Roy Umetsu, who is a managing partner of the New York office of a major Japanese corporate law firm, Mori Hamada and Matsumoto, Kazuko Ito, who is founder and vice president of Human Rights Now and a Japanese attorney at law. She will be acting as the discussant today. For full disclosure, I am a member of the board of the U.S. affiliate of Human Rights Now. And Akiko Sato, who is not in our picture yet, Japanese lawyer and business and human rights specialist, currently based in Bangkok, formerly with the UN Development Program. She organized this program and will provide us later with closing remarks. So today's topic is an area of ongoing interest. A few years ago, we had several speaker programs more broadly focusing on ESG and climate change and the social role of corporations. For those of you online, I think there will be some links appearing in the chat that talk about a few of the topics we discussed in those programs and also in an online symposium essay collection that is still on our website. In addition to these efforts focusing broadly on ESG, the environmental, social, and governance aspects of corporations, we also had a conversation with Kazuko Ito a couple of years ago, more specifically on business and human rights from a Japan or Japanese NGOs perspective. So we thought it was time to learn more about current issues and practices in the area of protecting human rights in supply chains. As we all know, there's been a lot of recent movement. Just in the last week, we have new tariffs. We read in the newspapers that large companies are scrambling to redesign their supply chains, and we're wondering what effect that will have on the protection of human rights in supply chains. So that's kind of the impetus for revisiting this issue that we have discussed significantly in the past. And in addition, when we think of business and human rights, we typically start thinking of supply chains, but there are also new issues, such as climate change, and we're interested in finding out how our panelists who work directly in this area are dealing with those kinds of issues. Our program today is 90 minutes. We will dispense with opening remarks, again, to maximize discussion time. Following our discussion, we'll move on to Q&A, both in person from the room and also from our online audience. As a reminder to our online audience, please use the Q&A icon to send us questions, not the chat function. Catherine Wilhelm, our executive director, who is not on camera at the moment, will act as a representative for our online audience and will pose their questions for them. So let's begin. I guess the first question is, how are all our panelists involved with business and human rights issues, briefly? And then what is the issue that's foremost on your mind today? And that could be a basic issue you've dealt with for past 10 years, or it could be a very recent development from the last week. We're interested in hearing about both today, I think. Noor, could you start us off, please?
Sure.
And please, for our online audience, get close up to the mic.
Yes, will do. So in terms of the work that we do on business and human rights, ICAR more broadly works on three broad things. ICAR broadly works on corporate accountability policy in the U.S. and advancing policy to hold corporations accountable under U.S. law. And we do that through three things. One is combating strategic lawsuits against public participation, lawsuits by companies against human rights defenders and environmental defenders to silence them and prevent them from speaking out against those corporations. The second way that we do this is through combating corporate capture and really trying to prevent corporate power from influencing U.S. policy as opposed to the public and Americans influencing policy. And then the third piece of our work is on enacting legal safeguards against corporate abuse throughout U.S. supply chains. And this third piece is where I work primarily. And we do a couple of things here, primarily legislative and regulatory advocacy with U.S. government institutions. On the legislative side, we have been advocating for the U.S. to implement mandatory human rights and environmental due diligence and require companies to really trace their supply chains and document and report on those supply chains to be more transparent about what's in their supply chains, but then also conduct human rights due diligence to ensure that their supply chains are free of human rights abuses, including forced labor and human trafficking. On the regulatory side, it's really to ensure that laws that are on the books are implemented as strongly as possible, and that includes laws like the forced labor import ban under the Tariff Act of 1930, Section 307 of the Tariff Act of 1930, as well as the Uyghur Forced Labor Prevention Act, as well as a number of others as well, but really trying to strengthen connections between U.S. government supply chain transparency mechanisms and human rights enforcement mechanisms, and ensure that the two are working as strongly as possible, but then also collaborating as strongly as possible. I think that the issue that is most strongly on our mind right now is a more recent issue rather than an old one, or maybe an escalation, but really how the extent to which the current government and the current administration is so tightly and closely aligned with corporations and to the extent that it's entrenching corporate power. I think one of the primary issues we're seeing is the obviously the current Trump administration is cutting government funding and cutting several programs within the U.S. government, many of which are programs that we think are really essential for holding corporations accountable for abuses throughout their supply chains, and even for programs that aren't being cut, kind of deprioritizing them. So one example is that there was an executive order issued a few weeks ago that paused enforcement of the Foreign Corrupt Practices Act, which is the U.S.'s primary anti-bribery and corruption law. The law is still in the books, it still exists, but the pause kind of creates an opportunity for companies to, it kind of raises a flag that corruption is not going to be as strongly enforced in the U.S., that that there's a push for it to be okay. And so that was a really big concern for us in terms of the forced labor import ban that the U.S. has, which allows the U.S. Customs Border Protection to prevent imports from coming into the U.S. if they're found to be made using forced labor. We're a little bit unsure of what that will look like, but we're hearing that Customs and Border Protection will obviously, under the Trump administration, be more focused on immigration and less so on trade. And so there's a concern that some of these laws that have been really essential in holding corporations accountable and preventing forced labor from showing up in U.S. markets are going to be deprioritized. And so from our end, that's the key issue that we're seeing that is really troubling is we've been working to strengthen these programs and to build stronger programs. And now we're seeing that these programs may not exist anymore or may be significantly deprioritized. So from our end, that I think is one of the major concerns we're seeing and hoping to work on.
Thank you. Roy, please.
Yes, thank you very much, and thank you for having me in this very important opportunity at the very good timing. I should say good timing or bad timing. I'm not sure, but good timing of the the year. So I'm Roy Umetsu, and I'm actually working at the Japanese law firm, and that law firm itself is we call it a corporate law firm. So I think I'm working mainly for the corporate side. So I think I'm not started my career as a human rights perspective, but I'm more on the corporate law at first. But for the last 10 plus years, I have been working very closely for this matter from Japan side, especially working together with the civil society people or other lawyers or governments or sometimes I also worked with the United Nations and so that how Japanese companies can actually understand correctly what guiding principles are requiring for the Japanese companies, and also there are some or a lot of gaps, between what Japanese companies were doing at the time and what union guiding principles are requesting. So I think I try to fill in the gap from the companies and corporate lawyers' perspectives, and it's sometimes a bit difficult balance because companies are more on pursuing profit rather than human rights issues sometimes, but that's actually what we need to understand, that's their mindset. So I think I try to be more constructive in the discussion with the companies, and because I have been assisting for the companies for the business perspective as well, for their M&A or for their other corporate activities, and that's why I somehow I try to get some confidence from the company side for those activities, but at the same time I also encourage the companies to try to start or try to enhance the human rights due diligence or human rights activities from the corporate side. So I think that's what I've been doing for the last 10 plus years, and I think Japanese situation has been dramatically changed especially for the last 3-4 years, and a lot of Japanese companies are actually starting to do human rights due diligence or those kind of activities, and together with my background as a lawyer, I'm advising a lot of international trade law, which means that the export controls or economic sanctions or those kind of issues, as well as the investigation type of work. So now I have been combining with those expertise. So I have been working a lot for the export control plus human rights issues, which is, as Nor mentioned, that some UFLPA issues, Xinjiang Uyghur issues, or other trade restriction for the human rights perspectives, or I have been doing some investigation about the human rights violation in the supply chains in Malaysia or in Indonesia, Thailand, Nepal, Bangladesh. Those are the countries where Japanese companies have a lot of supply chains and a lot of forced labor issues. So I think I have been working for the investigation for the companies, to try to figure out those issues. And the two big issues from my perspective is, one is a long kind of standing issues for the Japanese companies. So I think Japanese companies have started human rights due diligence or creating human rights policy, but I think my feeling is actually still it's a kind of formality only. So I think they created a human rights policy, but they actually do not implement itself, or they do human rights due diligence. Sometimes human rights due diligence just means sending questionnaire and that's it. But that's not the human rights due diligence. So I think how to implement effectively or substantially human rights due diligence in the supply chains are becoming more and more important in the Japanese community. That's one point. And the most recent one is actually my biggest concern is diversity, equity, and inclusion policies. And I'm quite upset, to be honest, by myself, what's going on in the US. And I have a lot of inquiries from the Japanese companies, obviously, what's going on in the US, what we need to do. So I think I can fully discuss later on, but I think that's one of the biggest concerns that I have at this moment.
Well, I think you're not the only one who has that concern, but thank you. Kazuko?
Hi, my name is Kazuko Ito. I come from Human Rights Now. So Human Rights Now is an international human rights NGO based in Tokyo, Japan, established in 2006 by the number of the professional, the lawyers, academia, and journalists, etc. And then so point of that Human Rights Now is to promote and protect human rights worldwide with special focus in Asia. Yeah. So we, after the establishment of organizations, we focus more on the states-led human rights violation. But in 2013, the Rana Plaza accident happened in Bangladesh. That strikes me a lot. And then so we feel like, the business caused a lot of serious human rights violation. We must be involved in these issues. And then so 1 year later, so we went to send a mission to the Bangladesh, and so the people suffered from that Bangladesh, the Rana Plaza incident, but not only Rana Plaza, but also many suffering in garment industry, but not only garment industry, but many other industries. And then so we should shed light on the issue, and we start how we start the business and human rights project in Human Rights Now. So we conducted later on that together with the Chinese NGOs and undercover investigation of that Uniqlo Chinese suppliers factories. That was very, very impactful investigation, and then that changed a lot about the Japanese corporations' tendency of the supply chain management and business and human rights. That we started the Business and Human Rights project. So we have three components of the business and human rights. One is the awareness raising of the UN guiding principle of business and human rights. And secondly, we conduct human rights investigations of the human rights violations in the supply chains. And thirdly, we do policy recommendation advocacy to that the same like mandatory human rights due diligence law adopted in Japan. It's a long way to go, but we try to change that the Japanese as a legal as outset of that business and human rights. That we are doing right now. And so my current concern is that the same like you guys, and the pushback is very, very serious, and coming from the United States. And so Trump administration just destroy everything about the business and human rights, ESGs and DEI, and that would affect to that entire Japanese culture of the business, and not only Japan, but also many, many countries. So how to push back this, how to overcome this pushback from that Trump administration, that is my concern. The second concern is that the Japanese practice is quite superficial on the human rights due diligence and all. Yes. For instance, currently, the Fuji company, this is very, very important company, famous TV company in Japan, just established that human rights policy, but there is no system to implement this policy at all. And then, so some sexual harassment issue happened, but then 3 or 4 persons just hiding these issues without, sharing the information with the compliance management, the division section of the company. It is difficult to pursue the human rights due diligence policy at all. So this is a huge scandal right now in Japan. So UN working group on the business and human rights conducted the mission to Japan 2 years ago, and they highlighted the sexual harassment and then sexual violence in the entertainment industries. So we are now focusing on this issue, and we conducted a survey to all TV companies, how their human rights policy is implemented. So we are sending all the questionnaire to their companies, and we are waiting for their answers. So it will come soon, end of the March. Let's see. So.
Thank you. Well, I'm interested in asking about how you see fundamentally how different countries deal with these kinds of issues, business and human rights, and more generally ESG. A few years ago, we talked about ESG and climate change, again, an important element of the social role of corporations. At that time, we characterized the EU as being very regulation-oriented, more of a legal approach with directives that were mandatory, at least in terms of information disclosure. At that time, it might be changing recently, at that time, at least in the US, we thought more of institutional investors like BlackRock, and we thought more of market pressures on corporations to promote ESG and other aspects of the social role of corporations. And in Japan, it wasn't quite as clear exactly what the approach was, but initially we viewed it as kind of a partnership between government and industry, particularly with respect to climate change, climate risk disclosure. Those are very broad categorizations, and they don't focus specifically on business and human rights. Do you find them helpful? Do you sort of agree with them? Do you think it may be different specifically with respect to business and human rights? or maybe was true but is now changing. What are your thoughts on how to characterize the overall basic approach to business and human rights in the EU, the US, and Japan? Roy, do you have any thoughts on that?
Yes, thank you very much. I basically agree with what you have just described, and probably a few addition if I can make. And the for the U.S. perspective, I think yes, we have a lot of investor market approach, but at the same time, I think U.S. also has the regulations, from the early stage. I think California has the Transparency Act, from I think 2012 or 11. I think more than 10 years ago, and the also, UFLPA itself, Uyghur Forced Labor Prevention Act itself has some power. I think so. I think it's still there are some laws. I think it's different from what the situation in Japan. I think in Japan we do not have any not only mandatory due diligence requirement law, but we don't have any mandatory disclosure regulation. We have some disclosure regulations in the annual reports. We need to disclose the sustainability, but I think we do not have any regulations. I think so. U.S. still have some regulations. I believe that's different. But for the Japanese approaches, I can add a bit more. If we call it positively, I think it's a cooperative approach. But if it's called it negatively, I think nobody wants to be a first penguin. So I think that's kind of, I'm not sure what that's the approach. So I think, what our approach is actually, I think, the tips to encourage the companies to step forward, actually, creating first penguin in the same industry. And if one company does, created, for example, they created the human rights policy, I think all other, competitors created human rights policy within 6 months. That's not good, to be honest, because sometimes I was requested by the companies that I want to create our company wants to create a human rights policy in 3 months, and could you please make it? What does it mean? Why I need to make the human rights policy for the company? So I think I need to discuss one by one, what the human rights policy means. But I think creating the kind of first, penguin is the key, and I should call it probably positioning side by side, culture is the have some negative impact. But if we create the effectively fast penguin, I think we can easily push forward the industry. I think so. That's the kind of situation I believe in Japan.
Thank you. Noor, do you have any thoughts on sort of how we should categorize what different areas do, different countries do?
Yeah, I think I would agree with what Roy said about the U.S. approach, which is that there is some regulation. I think there's one key distinction between the way the EU regulates versus the U.S. And like you said, the EU has kind of mandatory directives that provide certain systems and steps that companies need to follow in order to comply with the law. U.S. law works a little bit differently in that it's a little bit more blunt. So similar to the UFLPA or the broader forced labor import ban, these are kind of strict bans. And so U.S. law kind of doesn't tell companies how to comply with the law or what steps they need to take in order to comply, but there is a ban on certain activities within the supply chain. And that's kind of the way that the U.S. has regulated companies. So as you mentioned, there's the Uyghur Forced Labor Prevention Act, which prohibits imports of goods made using Uyghur forced labor or that are made within the Xinjiang region of China. And then there's also the forced labor import ban, but then outside of that, there's also global Magnitsky human rights sanctions, which are sanctions regimes that apply more broadly than just corporate human rights abuses, but applied to human rights abuses, and most recently were used for instances of forced labor in the seafood industry, and I believe it's the first time that there have been global Magnitsky sanctions issued for forced labor. But these are kind of blunt tools where if the presence of a violation exists, then the individual or the entity is blocked from participating in the U.S. market. Another example is there's the opportunity for criminal prosecutions for forced labor or human trafficking under U.S. law. So the Trafficking Victims Protection Act allows the U.S. Department of Justice to pursue cases of forced labor or human trafficking against U.S. companies that benefit materially from the presence of forced labor or human trafficking throughout their supply chains. There hasn't been a prosecution yet for a company benefiting from forced labor or human trafficking in their supply chain, but that is a law that exists, and that would allow the Department of Justice to pursue that case. But yeah, like I said, that there hasn't been an instance of that actually being used yet. Another example that I already mentioned is the Foreign Corrupt Practices Act, which doesn't necessarily tell companies how to avoid bribery or corruption, but just lets companies know that if they do engage in bribery or corruption, there will be a significant sanction. So on the human rights side, that's really how U.S. law has operated. There's very little by way of transparency or disclosure or reporting. The Uyghur Forced Labor Prevention Act has some element of that, where if a company if a product that's being imported does have the Uyghur region of China within their supply chain, then they need to provide evidence, essentially, that the product was not made using forced labor. But there aren't specific disclosure requirements. There isn't specific information they need to submit. It's whatever information that customs thinks is relevant in that particular case. It's very much case-by-case basis. So there aren't any strong transparency mechanisms connected to any of these blunt human rights enforcement tools. And it really relies on NGOs, journalists, and outside parties to report this information to the government to be able to take any enforcement action. And so from that end, I think that makes some of these tools, although very strong when they are used, quite weak, because it takes a lot of investigation from outside parties and from the government side to be able to use these tools, as opposed to requiring companies to disclose the information necessary for these tools to be more comprehensively enforced.
Thank you.
Yeah.
I know I listed you as discussant, Kazuko, but if you have any thoughts on sort of big picture,
Yeah.
how to characterize your approaches, please go ahead.
Yeah. So thank you very much. And first of all, Japanese approach, I can't say it is partnership approach. So because there is a lot of training of business and human rights, but actually Japanese government does not provide proper guidance at all. For instance, let's take the case of Xinjiang Uyghur region. So the Japanese government never ever take any position about that, what's going on in Xinjiang Uyghur region. If there is any human rights violations going on, any genocide is going on, no determination by the government. So because Japanese government has no history and asset to, determine what is human rights is all about. So Japanese government has, very lack of that human rights policy. So that is why they cannot make a proper guidance to the companies. That is why all the companies are so puzzled. Sometimes they are, like Uniqlo, just they are stopped to export other things to the United States. There is sanction is going on, yeah. But some other company just continue to have trade with Xinjiang region. So because of they are afraid of Chinese pressures, because Japanese government say never nothing. So that is why so company has no idea what is the right things to do. So I think that the Japanese government should take a more role. Like in this case, the United States is taking the tariff laws and tax laws, and then so there is some determination of what is forced labor, child labor, etc. So that kind of investigative mechanism Japan needs. So that's something I want to say. And another thing is that so investor-oriented approach sometimes work for Japan. For instance, in case of the Fuji TV, etc. But I think this is very capricious, and then their activity is quite limited. This is not consistent. So if that all the company consistently implement the UN Guiding Principle of Business and Human Rights, I think the EU types of regulatory approach is the best approach. That's something I think.
Well, great, thank you. Well, picking up on that, so if different areas of the world have different policies and different government regulations, how do they spill over and affect large companies that are operating in all these different areas? Mm-hmm. For example, any company that's not headquartered in the EU would presumably still have to follow the directives, at least for their EU activities. I recall when I was in Japan, and Roy can confirm or correct, that there's no real Japanese effective bribery law or Foreign Corrupt Practices Act, but they worry about U.S. And to a lesser extent, UK enforcement and laws that they still need to comply with, even in their business dealings with other Asian countries. So when you're discussing this with corporations or with other organizations, so how much thought do you give to what's going on in these other jurisdictions? Have any thoughts on that? Roy, you want to go ahead?
Okay, thank you very much. One point at the foreign craft practice, we have, Japan has, kind of foreign craft prevention, regime, but I think it's much, loose. I mean, the sanctions are much smaller than compared to US or UK. So I think, a lot of Japanese companies are focusing on how to comply with the US FCPA or UK Bribery Act. Although US FCPA has been suspended, I'm not sure what will be going on, but I was surprised, already enough for the last 1.5 months. That one of the biggest surprises is actually suspension of CPA. But anyway, so, and I think, yes, true, but I think, a lot of Japanese companies are also, affected by the non-Japanese requirements, especially, because at least, indirectly, Japanese companies are dealing with the US market or EU market. Although, for the last 2 weeks ago, I think, omnibus law actually has limited the, the supply chain for only the first year, unless you have any other, reasons. I think so. That's why it may may limit the scope of the human rights due diligence by the EU company. But still, a lot of Japanese companies are caring about what CSDDD is, requiring, what CSRD is requesting, and so I think, that has a lot of impacts. But at the same time, I think, traditionally Japanese companies try to follow what Europe and America are doing. We have the wording in Japanese, a Japanese speaker can understand obey. Obey means Europe and America. So we try to understand what Europe and America are doing. But now Europe and America are doing very differently, especially for the last, 1.5 months. So that gives a lot of trouble for the Japanese companies. We are trying to follow somebody, but teachers are saying totally different things. So I think that's actually creating a lot of difficulty for Japanese companies. That's why I'm now telling to the Japanese companies, we are losing teachers. So I think you need to decide, your policy. You need to decide what you want to do, and you need to do, by yourself. That's the timing that we are facing at this moment. And today, actually, I intentionally wore this tie, and actually, because this tie actually was they're made by the brand called Heralbony. Heralbony is the company actually who are trying to kind of create an artist who is the mentally or intellectually challenging people, but they're treating those people as an real artist. So I think they will never sell this tie with a cheap price. So this is very expensive, actually. This is one of the most expensive ties that I have. But I think they are sticking their policies, but they treat those mentally or challenging and intellectually challenging people as a real artist. Because sometimes they're under the pressure that you can sell it cheap, or it's for the social purposes, but they're not. So I think they stick their own policy and try to create the roles. I think that's why it's sometimes wear this tie to teach or to tell to the Japanese companies that this is the way you should think about. You're not following not for somebody else, but you need to follow your own policy. That's the timing that we are facing at this moment.
Excellent. Noor?
Yeah, I mean, I think this plays out in a number of different ways. I think one thing obviously is looking at the U.S. response to the CSDDD, the Corporate Sustainability and Due Diligence Directive in the EU, and just seeing the pushback that the U.S. government has had even before Trump took office against having U.S. companies need to comply with the CSDDD once it comes into force, and just seeing that pushback and how much opposition U.S. companies have to being able to being required to comply with European laws. And I think that raises the question of the political impact of the extraterritorial impact of some of these laws. But also, I think that has kind of made us think about how we want laws like mandatory human rights and environmental due diligence laws in the U.S. to apply. And for the human rights and environmental due diligence law proposal that the U.S. that ICAR has, it would apply kind of similarly to the FCPA to U.S. companies and companies that trade on U.S. stock exchanges, kind of following the way that the U.S. usually applies extraterritorially, which is U.S. companies and companies that have that touch and concern the U.S. to a certain extent. But then I think the other way this plays out is this makes me think of the forced labor import ban and how things like forced labor import bans really can only be effective if they exist across jurisdictions, because if a product is prevented from entering the U.S. market, that importer can very easily go to Canada or Mexico or back to Europe. And so if that's the case, then there's not quite as much of a disincentive or a sanction towards that company, because that product is still being imported somewhere. They're still making money off of it. And so things like an import ban, I think, are especially effective if they can apply, if they exist in different countries. And I know that there's a proposal for that in the EU right now. And so I think if that movement, and I know there's a movement to apply these import bans across different countries, and so if that is successful, I think that can make that type of legislation or that type of accountability mechanism much more impactful.
Great, thank you. Kazuko, I know you've also been working on trying to get some new due diligence for human rights legislation in Japan without much success so far. Can you tell us a little bit about that?
Yeah, so yes, so we are, the CS3 is sort of the model for our organization, and we are proposing to the similar types of UN mandatory human rights due diligence legislation to be adopted by the Japanese government. And also, so we are approaching to the many member of parliaments, but now that there are lots of setback and pushback from the US, and omnibus legislation is coming from the CS3. It's not great time at all. So that's the situation. Yeah, but take the situation opportunistic way, and so yeah. So I think that over 500 Japanese companies are applicable to the CS3.
I think much less.
Much less?
Because I think the original number, I think it was around 500, but I think at the end of the day, I think they increased the threshold, right? Last February, and then it will be. I'm not sure the accurate number, but probably 100 or so.
100,
I believe,
100.
directly affected by.
Okay.
By
Okay.
But this is not accurate number.
Yeah. Yes, but still we have 100 leading company. The CS3 is applicable. And then there is a significant setback of that omnibus by the omnibus legislation. But still, it's much better than the current Japanese, legal framework. There is no legal framework at all. So we can just follow a little bit about that omnibus legislation. And at least the German legislation. And then so we can find that the best way to fit Japanese the legal environment. And then so, because there is nothing, no regulation at all, no disclosure rule, no mandatory human rights due diligence law. So that is why, so we want to achieve something real next year, despite the very, very difficult circumstances.
Well, thank you. That's a good reminder that in the end, we generally rely upon the corporations themselves to devise and implement business and human rights policies. So we should talk for a moment about what kind of incentives, both kind of positive reinforcement and negative pressures, do companies face when they think about policies and implementation in this area? What's important to them? What do they care about? Noor, would you like to go ahead?
Sure. I mean, I think from my perspective, I think the incentive that works most effectively with companies is sort of a negative reinforcement of really significant fines and sanctions for violations. And I've heard this from people who have worked in the private sector and switched to NGOs, but worked in the private sector on business and human rights. And the thing that they've said across the board is that companies will not conduct human rights due diligence. They will not take steps to improve their supply chains unless they are required to do so. And obviously, there are certain companies that will take those steps voluntarily, but across the board, some of the largest multinationals will not do that kind of work and put in that investment unless they're required to do so. So that is the most significant. That's the most significant push for companies to do that. But then outside of that, I think the other incentive that could be really helpful coming from the NGO side is sort of benchmarks that kind of rate companies on their human rights impacts and the work that they do from a human rights perspective, because then that creates an opposite, which is kind of a race to the top. And for certain companies, if these things are published within kind of specific kind of trade journals and things like that, then it makes an impact for them, and it highlights their name in a way that supports their business. And so those are the two primary incentives that I see. But I think overall, the most important incentive really is mandatory requirements, significant fines. I think that's what's made the Foreign Corrupt Practices Act so successful, is that not only does it fine companies, but it levies really significant fines against companies that do violate the FCPA. And if we're able to create a sort of human rights equivalent to the FCPA, that would be a really significant step that would really completely revolutionize corporate behavior when it comes to human rights and supply chains.
Okay, I take it you're not holding your breath for that to happen right away.
Not right now.
Not right now. Okay. So, Roy, you're the one who deals most directly in advising corporations. What's your view on what they care about? How do we influence them?
Yes, this is the kind of never-ending questions for me. I think I'm trying to create how to persuade the Japanese government or Japanese management on a daily basis. But I think I start with sort of like negative pressure first. I think the 2 points. So negative pressure. First point is actually, as already mentioned, that especially Japanese companies are caring much more, caring about what the other competitors in the same industry are doing. So I think the biggest pressure for the management is actually the other competitors already has the human rights policy. The other competitor already has done the human rights policy, human rights due diligence, and they have a grievance mechanism over there. I think that's the most efficient way to persuade the management, and that's probably could be the only sole reason for the management can think about doing this. I think so. Creating the first penguin is the kind of most effective approach for that industry. That's the first point, and the second point is, as Nora mentioned, that I think the legal requirement or compliance type of requirement or media pressure about the press coverage of the Human Rights Now has done, but a lot of press coverage for the human rights violations in the supply chains in South Asia, in China. I think that kind of influences has a lot of impact for the Japanese management. So it's a kind of protection of the reputations or crisis management type of work that has a lot of an impact. But not only that's kind of negative pressure, but also I have seen some positive impact as well, which is, I think, especially at least management wants to make the company better, and better for the employees, better for the communities. I think better for the young people, and I think to be quite honest, no management just wants to have profit and have the bad reputation of the company. Every management wants to be seen as a good company. So that kind of incentive can be used as an incentive for promoting human rights due diligence, especially for the what I felt was a recruiting process. So I think especially younger generations has much more sensitive about environment or human rights issues. And in order to have a very effective recruitment process, Japanese companies want to show that our companies are caring about those issues. So I think that's kind of incentive that we can use as well. And also some of the investors' pressure as well. As Kazuko-san mentioned, I think it's not always they're very active. They are not always very active, but now we are seeing some active investors as well. And also, I have been requested by the institutional investors, about the training for them as well. What's actually a few years ago, institutional investors in Japan actually sometimes did not understand what they need to ask to the company, what they need to point out to the company. So I think I also have done, or considered together with them, what is the constructive approach from the investor side to do, for the human rights approaches. I think that's now becoming one of the ways to do that, but still not very, as active as US or Europe, but I think it's becoming more active than before.
Well, thank you. Well, Kazuko, you're the one who probably brought the issue of business and human rights to everyone's attention in Japan through Uniqlo and other factors. What's your view of the influence of an NGO on corporate behavior? I'm sure it's not as much as you would like it to be, but nevertheless, do you think you have at least some influence?
Yeah, so I hope so, but I'm not quite sure. So we hold press conference all the time. Yeah, yes, please. Yes, yeah. Thank you so much. Yeah, I don't know if it's has impact. I would like to know, from the corporate side what they perceive us. Yeah, but anyway, so we held a press conference, but usually the government, the company's position is just, that they don't care. They just ignore sometimes, and they just they respond in a very superficial manner. We have a human rights policy, and we are doing human rights due diligence, but that's something you are asking to us. This is related to the specific trade and specific business. We can't answer to the specific issue at all. That is a typical answer by the companies. This is very difficult, but we continue to do that. And then so our approach is when it's combined to the media attention, media coverage, and also the investors, pressure. So that's something hugely worked. Yeah, so that's the situation. So NGO itself has a little power, but we need to work together with media and investors. We are so surprised when we send a letter to a very influential government sector in Japan, not Uniqlo, but they just ignore to our activities. But the investor was watching to our activities, and then investors, just communicated to us, and then so we answered to that, and then so they just decide. This company is in the watch list. You have to change your behavior. Otherwise, we will divest to your company. That was notified by some investors. Then dramatically, the company's behavior changed. So we are sort of ally. The investors are ally of us.
Okay, excellent. Well, as we stated at the outset, obviously we're in a situation now where things are rapidly changing. And just in the last week or so, we read about how tariffs are scrambling everyone's supply chains. And presumably that will also affect human rights enforcement if we have to come up with new compliance schemes or new arrangements for due diligence. Have you seen your members or your clients reacting strongly right now in the last week or so, looking for new supply chains, new things to do? Are you consulted about these things and as if it were an emergency? It's hard to know, or we academics just read the newspapers. But I'm curious to know what's been your very recent personal experience. Roy, go ahead.
Yeah, it's a difficult question, but I think at this moment, at least for my clients are mostly Japanese clients, but Japanese clients are, I wouldn't say wait and see status, because I think it's more primitive than wait and see. They are overwhelmed by the daily changing, information about creating tariff, and within 8 hours they are they are kind of withdrawn, and sometimes a lot of D&I policy, pushback for the D&I policy, and I think so. It's kind of overwhelmed, and it's still taking some time to digest, what's going on, and before we digest it, that has changed. So I think then we need to digest, I think, something more. So I think that's the kind of situation at this moment. But obviously it will affect a lot of supply chains. Especially for example Mexico. We have a lot of automotive sector supply chains over there, and we are heavily relying on Mexican supply chains for the Japanese automotive industries. And if they change the stance against China, I think we have a lot of China is geographically as well, but also economically, very close to the Japanese economy. So I think we need to admit that we have a lot of supply chains in China. So I think that may change as well. So I think yes, that may affect a lot, to the Japanese community. So we need to figure out. But my concern is actually human rights due diligence of supply chains comes later. So I think the first reaction is how to avoid the tariff. How to create the supply chain with a less tariff. I think that's the first priority for the management. Obviously, they don't care about the human rights issues. I believe, in creating new supply chains. So they first create it. So I think that's inevitable from the management perspective. So I think what we can do, from my perspective, is okay. You can create the new supply chain, but immediately after that, you should also check about you should do the background check. You should do the human rights due diligence. At least the initial simplified check, for those new supply chains. I think and they try to make that time gap as as small as possible. That's probably what I can do. But I think that's what we need to do going forward.
Noor, have you been contacted by frantic people recently?
Not really, because we don't work directly with companies, but I think my assessment is kind of what Roy is saying, which is that if companies are scrambling to avoid the tariffs, then they're not being very conscious about the human rights impacts of their supply chains. The other thing I'll say is that if companies are having to pay these significant tariffs, they're also less likely to be prioritizing human rights due diligence, because they're not going to put money towards human rights due diligence when they need to put it towards paying these tariffs. So that's the other impact I would say that I see. But other than that, we're similarly just waiting to kind of document what companies are saying and what ends up happening with that.
Great, thank you. Kazuko, have you noticed anything very recent? No?
No.
You're still fighting for due diligence in Japan. Okay, yeah. We'll let you do that. I think it's still a little bit early, but we want to hear, we do have closing remarks coming up from Akiko Sato, so I think I'd like to open the floor for questions now, and then go to the online questions, and then we'll let Akiko finish up at the end. Yes, please.
Can any of the panel members provide specific examples of successful criminal prosecutions or civil cases targeting human rights violations in the supply chain?
Okay, any specific examples of criminal or civil successful litigations regarding human rights in the supply chain?
So what I can say, I want to respond to that to say that I think in terms of litigation, I think the answer is no in the U.S. context, because one thing that has come up a lot is for the laws that do allow for litigation, for litigating these issues, like the Alien Tort Statute, the Trafficking Victims Protection Act, that allow victims of human trafficking, forced labor, and other abuses throughout supply chains to pursue cases in U.S. law. A lot of these are really severely impacted by U.S. courts' distaste for extraterritoriality. And so the fact that so many of these abuses are happening outside of the U.S. has really limited, and the U.S. courts, like I said, distaste for cases that have a non-U.S. element is really preventing these cases from moving forward. And so that is the big thing that U.S. civil society working on these issues is trying to address. I know that there was an effort to add an amendment to the Alien Tort Statute that would explicitly allow for extraterritorial jurisdiction. That I don't believe that didn't pass, and I don't believe it's been reintroduced, but I think it's something that is an effort that folks would want to continue to move forward on. And I believe, and there have been efforts to try to relitigate elements of the Trafficking Victims Protection Act, but both of those are laws that essentially are very, very hard to litigate when it comes to cases of abuses in supply chains. I think the place where I can say there has been success, and again, I don't know how successful this is in terms of impact, but at least in terms of some form of accountability or enforcement, is the Tariff Act, that the forced labor import ban. Up until the last couple of years, there have been it's been pretty, I think, relatively heavily enforced. There have been, I think, about 7 or 8 import bans every year against specific importers. The last couple of years, that hasn't been the case. I think there have been 3 over the last 2 years. And a big part of that is because Customs and Border Protection has been focusing on implementing the Uyghur Forced Labor Prevention Act. I don't know to what extent that has been successful, but I do know that that has seriously impacted trade, and goods that are on the priority list for the Uyghur Forced Labor Prevention Act are really having to wait at the border and prove that those goods were not made using forced labor. And so to a certain extent, there is success there. But again, like I said, with the import bans, if they don't import into the US, they turn around and import to a country that doesn't have an import ban. And so that's something to consider. And so it's successful in the sense that the law is being enforced, but I'm not sure if it's not necessarily strong enough to be changing corporate behavior throughout supply chains.
Can I,
Maureen?
yes,
Please go ahead.
thank you very much. Yes, I agree with what Nora mentioned. So I think, one of the typical influence, I think, as you should, litigation, but enforcement action by the CBP, Custom Board Protection, I'm not sure, CBP. I think, in this, for example, Japanese companies' supply chain issues in Malaysia or Indonesia, Nepal, Bangladesh. I think some of the cases actually, human rights activists over there and NGOs reported to the CBP. I think, and that has sometimes significant impact for the behavior for the Japanese companies, because U.S. market is such a huge market for the Japanese companies, and if they cannot sell the products in the U.S. market, that may mean a lot for them. So I think that has one impact. And also for the litigation purposes, I think I'm not sure whether actual litigation result came in, but I think at least some of the Japanese companies are under the pressure of being litigated in the U.S. And they in some cases I think they kind of warning that they will bring the cases to the U.S. court. I think that creates some pressure for the Japanese companies to solve those issues. Those are all supply chain issues in Malaysia or Indonesia, those kind of areas. And the last point, I think, especially for criminal cases, I think, in Japan, I think, some of the harassment cases, I think, are actually were brought to the, criminal court, in Japan. I think, in one of the cases, I think one of the largest, kind of advertisement company in Japan, I think they have the, harassment issues and also the overworking issues, and actually one of the employees actually committed suicide, and that creates this. I think it went to the criminal court, I believe. I think, but that has sort of impact for other Japanese companies. But once we have those kind of issues, the management could be, or managers could be, even criminally, prosecuted. I think that's also, has some impact, on the Japanese community.
Can I add one more thing?
Sure.
I just remembered there actually is one example, which is the Chiquita case, which was recent. It's been ongoing since I believe the 80s, but a case basically against Chiquita Bananas for contributing to and financing militias in Colombia, and the case was, I think, many victims and their families of the armed group that was financed by Chiquita. Chiquita was ordered to pay them a really significant settlement recently. And again, this is a case that's been going on for like 30 years. And so that's one positive example.
Under what law was
I believe that was also the Alien Tort Statute. I can double check to make sure. Yeah, I'm not 100% sure, but I believe it is the Alien Tort Statute.
Okay. Yes, Nishita.
Thank you so much for your presentations. In relation to that point, I have a question about the Kashef case. How much that is attracting attention. It's a case about the victims in Sudan, and the government committed atrocities against these victims, and the BNP Paribas is the defendant because it was financing basically the Sudanese government, and the suit is still pending at the Second Circuit in the United States. And interestingly, the coordinating subsidiary of the BNP Paribas was located in Switzerland. So the court said that Swiss law is applicable to these tortious claims. But it seems that there is a good chance that the victims, they are now resident in the United States, could get some kind of damages. So I don't know how much it is being discussed, but at least among academias, it's attracting attention. Thank you.
Okay. Next, please, Chris.
I have a question in regards to corporate accountability potentially being included in international criminal court and in the international criminal law for corporations who have committed atrocity crimes of an international level. What are your thoughts on that? Do you think that's something that we could have in the future, especially in regards to the draft Crimes Against Humanity Treaty? I know there's also talk on including corporate accountability in this potentially new treaty as it's in the 6th committee right now. So any ideas on that? Could it work, since it seems like we don't have too much national litigation that's successful? Could we go to an international level and have a bit more success?
Any comments?
I can speak to that a little bit. So I think one thing to keep in mind with that is the one difficulty there is that I don't believe corporations, I don't know if there are countries where corporations can be criminally prosecuted as corporate entities and not as individuals. Typically, criminal law applies to individuals and not entities. So that's one thing to keep in mind. And I think it's a little bit different just because with criminal sanctions, it's typically, I mean, I guess there are fines, but also it's like jail time and things like that. And so I'm not sure how that applies to a corporation. But I think a couple of things are really important there. One is that there have been in international criminal proceedings for war crimes and crimes against humanity, corporate actors have been prosecuted. Business people who are involved in companies that financed war crimes in Nazi Germany, for example, in Rwanda, in Bosnia as well. These were like, there are plenty of cases of this happening on the international level in the context of different conflicts. And so I think that's something, I'm not positive, but I believe there have been some of these cases, or actually there have been these cases on the international criminal level. I don't know if they've happened at the ICC, but I see no reason why business people couldn't be prosecuted in the ICC. And I absolutely think that they should, because businesses play a really significant role in conflict, in financing conflict. The other thing I'll say is this kind of raises a question that I think is really important when thinking about transitional justice and post-conflict prosecutions and things like that, which is that some companies make a lot of money off of conflict. And there's a really significant amount of war profiteering. And I think there's something to be said about thinking about not just prosecuting these people, but also thinking about, like, how can all of that money that they made, everything that they exploited people for, how can that money go back to the people that were impacted by the conflict in a post-conflict setting? So I think that's something to think about as well, is what can these cases look like where they can result in a financial settlement that can go back to the individuals who are impacted by the conflict?
Yeah, I'm also positive of the amendment of the Rome Statute. So I remember that there was a deliberate discussion about how to incorporate the corporate into the Rome Statute. There was a French proposal French government was, very, very enthusiastic, include the corporate accountability in the Roma Statute. But many other jurisdictions, like United States, they opposed strongly, and it didn't happen. But then the current situation, the increasingly needs that corporate accountability, criminal accountability. So there is some way to include that not only that individual, but also the corporation could have criminal responsibility. There's a mens rea problem, and then so criminal intention, and for instance, the genocidal intention. That can be only possible for that individual, not corporation. That is a theory, but you must overcome that kind of theory. We can find a good solution in the future, near future. I hope so.
Okay. Maybe one more question, and then we'll go online. Please, go ahead.
Okay, so I fully agree with Umet Sensei that peer pressure or any kind of negative pressure should be the best motivation for Japanese companies. But it can't be innovative or driving force to move forward the society. I don't mean the Japanese society, but any society, their supply chain exists. So we should admit that it's very difficult to change that nature of Japanese companies. My question is, how can we encourage Japanese companies to be innovative as a human rights defenders?
So how Japanese company can be
Innovative. How can we encourage Japanese companies to be innovative?
innovative in doing the new new approaches for the human rights due diligence or grievance? I think, for example, it's a good question, difficult question to answer. But I think probably it's as you mentioned that it's quite difficult to request the Japanese companies to do something innovative. I think in that case, probably Japanese companies economy is much better now. I think because we are kind of lacking of innovation for the last decades. But I think probably what we can do is actually to create the innovation from the society, from the expert. I think and not only relying on the Japanese companies voluntary efforts. And from that perspective, what I can probably introduce, I'm not sure it's very innovative, but I think what I have worked with, but I think not myself, but I think other colleagues are working more on the on that issue. But I think we created the center called JSA. Probably we heard that, the Japan Center of something and remedies. Yes, engagement and remedies, and that's actually I think still it's ongoing. But I think because like 3, 4, 5 years ago, I think we have serious issues about the grievance mechanism. No Japanese at least almost no Japanese companies had substantial grievance mechanism in the companies, and it's also very hard for the company themselves to create the effective grievance mechanism. They actually create the window on the website, but nobody use it, right? Because it's only in Japanese or in English, and no Bangladesh people, no Nepal people in the supply chain will use it. So I think we try to be very more effective. And also once we receive the report, we need to constructively solve those issues. But we didn't have that kind of expertise, so we tried to create some third-party center for solving or creating those grievance mechanism and that can be used by the civil society side as well as the company side, and they try to be to do that. And that's, I'm not sure it's very innovative, but I think that's how we thought should be the solution, because we cannot expect the companies to come up with the idea. So I think we expert or some those who have enthusiasm to create something new to the company and to propose it to the Japanese companies. And actually now it's becoming well received. I think more than 50 companies are now becoming the member for that. And I think they are receiving a lot of repos from those grievance mechanisms. Although it still has some challenges to be more effective, but I think that's changing the society. So I think it's not a perfect answer, but I think we try to collaborate, or we try also the expert also try to create some innovative approaches and provide the options to the Japanese company. That's one of the ways we can pursue.
Well, thank you. Well, let's get at least one question or two if we have time from our online audience. Catherine?
So the question is, in the United States, is there a significant impact on companies that engage in human rights violations, such as through consumer boycotts of their products? That's the first part of the question. And secondly, what do you think are the reasons that consumers might develop a stronger awareness of preventing human rights violations, even at the cost of sacrificing their own benefits, such as purchasing cheaper products?
Boycotts. Do we know anything about boycotts?
Yeah, I mean, I know that it's a method that's been used, obviously. I don't know to what extent it is or isn't successful. I think that they are successful, at least that's kind of what I've heard. To what extent, I'm not really sure. In terms of raising consumer awareness, I think something that would be important, something that at least myself as a consumer I find important, is identifying alternatives. So companies that engage in best practices, companies that do have human rights conscious supply chains, so that I can turn to them as alternatives to the multinationals that are kind of the monopolies that we see all the time and are more readily available. I think speaking for myself as a consumer, that's something that I think would be helpful, is just having the alternative to the companies that are engaging in the human rights abuses.
Great. Okay. And another question is about this goes to a little bit follows on what you were asking about how to influence Japanese companies to change, right? There's been an increase in tourism, foreign tourism to Japan in recent years. Is that having any impact, especially among younger generations, on Japanese companies' behavior with respect to human rights? So I guess the question is really, have tourists affected the behavior of Japanese companies?
I'm not quite sure whether those are affecting, but I think probably since because I'm not living in Japan at this moment, I'm now living in New York, so I'm not quite familiar with the impact. But I think probably about 2 points I can say is actually probably some of the tourists, some of the non-Japanese people who are conscious about those kind of issues actually can pay more money, I think more expensive price rather than the normal price or cheaper price. I think so for example, I think in the US actually I try to use more Amtrak rather than airplane for example for the emission issues, and I think that kind of mindset is not still common in Japan, but I think probably some probably non-Japanese people are trying to use more on train from Tokyo to Osaka rather than taking planes or whatever. I think that kind of culture may affect some business behavior in the US. But at the same time, I think flip side it actually I think under the news, because I didn't feel it, but under the news and under the Japanese news actually we're also talking about the over tourism. That is damaging the nature, damaging the people, local people over there, damaging the culture, history. I think that's also becoming an issue. So I think it's not affecting in a positive way, but it is affecting that a little bit negative way in Japan. But try to protect the culture, or sometimes we have some indigenous area as well, but that also are affected by the over tourism. So I think that's also another point that we are discussing.
Certainly, too much of a good thing. Yes. Yeah.
Well, so I think we should move on, because we're expecting some enlightening closing remarks from Akiko Sato, who is the main organizer of this conference. Akiko, please come up.
Thanks again for first of all the NYU for the organizing this event, and also as Human Rights Now that we are grateful for having this partnership. Actually, this is the first time to attend CSW, but during this time, the people that are coming from all over the world to think of the females' rights. I think that this is of course the quite related to business and human rights. And actually, my career on business and human rights has started by engaging with the local community in Cambodia, where that I used to live in before becoming a lawyer. And there are the people who are forcibly displaced by developing the project. And that is the moment that I, encountered the idea of business and human rights. So before that, my mind is that human rights that should be responsible or that should be protected by the states. But then after the learning about business and human rights, I really hope that the role of the private sector should be emphasized, and this can lead to more sustainable and responsible the community or the society that that we all are benefited. But then now when we look at the reality, as we all discussed today, and as all the great panelists already emphasized, that we are they're looking at the bit the unprecedented reality. And that is of course why that we should come together, and we should not give up what the UNGPs are trying to achieve. Then that I also like to draw your attention to what's also going on in the rest of the world. Although today's discussion is more focusing on the US and Japan, but of course there are the people who are affected by business activities in so-called global south. So since last month, for some reason, I've been traveling a lot. It is not the good for the environmental reasons, but for instance, I traveled to Indonesia, where I attended the workshop on just transition with the many indigenous people from Indonesia or the Philippines who are affected by the nickel mining industry. And also after that, I traveled to Djibouti in East Africa to participate in the training on human rights due diligence for the Ministry of Foreign Affairs and the National Human Rights Institutions in the region. And they're so, they're sort of keen to follow what's going on. They're keen to have the more effective policy on business and human rights. Although some of the countries like Sudan or the South Sudan are still affected by conflict, but they're trying to be hopeful, or they are trying to find the solution by implementing the business and human rights the policies, which are really encouraging me. And there is actually the one thing that the US and Japan has common, which is the lacking of the National Human Rights Institution. And this is quite powerful. The government, kind of like the public institution in which promotes the business and human rights in the many countries in global south. And when look at looking at the region that currently I live, for instance, Thailand. Thailand is the first country which they adopted National Action Plan on Business and Human Rights, and they already had the second NAP 2 years ago. And Indonesia, Vietnam, that they already introduced National Action Plan, and Malaysia that has recently published a National Baseline Assessment, and they're planning to introduce a first NAP within this year. And in terms of the mandatory human rights due diligence, again, Indonesia and also the Thailand are keen to have the mandatory human rights due diligence in the near future. Particularly the Thailand, they're quite serious about that. Of course, there are the reasons because they would like to become a member of OECD, and also that Thailand has a history which has been criticized of its human rights violation in some industries, such as the seafood industry. So there are, of course, for some economic reasons, the governments are serious about business and human rights, but which is, of course, the good things to they have the common idea, so that the affected people are protected. So as many of our distinguished speakers mentioned, I think one of the serious issues that we see among the companies, either the US or the Japan, is that the companies tend to look at how to implement human rights due diligence. I don't mean that they're looking at the approach, or they're looking at their way of implementation is a bad thing. But without considering the why, companies need to respect human rights. Companies cannot have the effective human rights due diligence, I believe, and which Also, there are lead to the lack of stakeholder engagement, meaning that the voices of those who are affected are totally missing in some human rights due diligence. So as NGOs, I think the critical role is to bridge between the voices of stakeholders and the companies, so that companies can also listen to the voices of people, and the people, and also those who are affected feel encouraged and also empowered to deliver their voices. And also this year, it is a very critical moment for Japan, because the Japan NAP is now under review, and the second NAP is supposed to be finalized within this year. And at this moment, there just like an overview of the second NAP that is available only in Japanese, but it includes some important topics such as environment as a new topic relating to business and human rights in Japan. So as we all see, the impact of climate change is significant, and of course climate change is human rights issue. That's why the right to clean, healthy, and sustainable rights is now paid the greater attention. And I think that the company that should look at climate change as a human rights issue, but still, which is I think in my view, the lacking when you look at the practice of the companies. And not only climate change, but also biodiversity and the environmental issues in general should be considered as human rights. And also, which leads to the meaning of having the UN Guiding Principles on Business and Human Rights, which is about the making the society the more sustainable and also responsible for all. And again, maybe some of you are getting tired of listening to this word, but no one left behind. I still I want to believe in this word. That still that we can have we can have hope to achieve this like a mantra, or this like the slogan, by coming together and by collaborating with each other, with more trust, and also with more mutual respect. So I hope that today's discussion that has brought some new aspects, or there's some new ideas to you all, and from tomorrow that we will restart, or we will re-energize ourselves and to work together. And I hope that this conversation will be continuing. Thank you.
Thank you, Akiko. I feel re-energized just from listening to you, actually. But so we're about 2 minutes early, but I don't think we should take any questions at this point. So I would like to apologize to people in the audience if we did not have time to get to your questions. And I would like to very much thank our panelists and Akiko Sato for this very interesting and wonderful discussion on a very timely topic. I'd also like to thank our audience, both in person and online, for joining us today. Thank you and goodbye.